Okay, thank you. Good morning. I welcome you to our next panel, Political Impediments to the Fight Against Impunity. And I welcome my very esteemed guests here on the panel. To my immediate right is Her Excellency, Dr. Atalia Molokome. Since May, so just very recently, she's been appointed as Ambassador of Botswana to Switzerland and to the UN office in Geneva. In her very rich academic life, she has taught law at the University of Botswana. She is a founding member of several human rights organizations. She is the founding head of the gender unit at the Secretariat of the Southern African Development Community. She was a judge of the High Court of Botswana, an Attorney General of Botswana, and in this position she represented Botswana in various international bodies. And in 2016, Dr. Molokome also qualified as an international arbitrator and is a fellow at the Chartered Institute of Arbitrators in London. To her right is Mrs. Maria Camila Moreno. Since 2011, she is the head of the International Center for Transitional Justice in Colombia. She has been involved in negotiations between the FARC and the Colombian government and has deep insights, brought advice to both parties, and brought them or helped to bring them to the negotiation table. She's a specialist in working with ethnic communities on issues related to collective rights. And since 1999, she worked in the formulation, implementation, and evaluation of human rights public policies with emphasis on vulnerable populations. She has a rich experience in working with many different public institutions and offices, and she's done extensive research on such topics as human rights and prisons, access to justice in Colombia, political participation of indigenous people. To her right is Dr. Serge Brammertz. He comes from Belgium. He is currently a member of the International Association of the Prosecutors. He has been appointed by the United Nations Security Council as Chief Prosecutor of the Mechanism of International Criminal Tribunals in 2016, and he has an extraordinarily rich experience in investigating and prosecuting severe international crimes. He was the head of the Federal Prosecution of the Kingdom of Belgium, first Deputy Prosecutor to the International Court of Criminal Justice. From 2006 to 2007, he was Commissioner of the United Nations International Independent Investigation Commission into the assassination of the former Lebanese Prime Minister Rafik Hariri. In 2007, the United Nations Security Council appointed him as Chief Prosecutor to the International Criminal Tribunal for the former Yugoslavia. And he was appointed by the United Nations Security Council as Chief Prosecutor of the Mechanisms for International Criminal Tribunals in 2016. So I could not ask for a better panel than this for this subject that we are facing now. There is a very famous late East German dissident called Bärbel Bohley. She once said, "We wanted justice, and what did we get? We got the state of law." State of law is important in order to bring people to court, but courts alone are overcharged and are unable to deliver justice for all victims. I'm a journalist. Journalists think they know everything. They know nothing, but they write about everything. So let me dive directly into the subject. Transitional justice entails very different aspects, a much broader approach. Not only conviction, it's reconciliation, restitution, reparation, just to mention a few. Countries so far have dealt very differently with transitional justice. There is no manual, and there is no master plan. There are different histories, different cultures, legal cultures, different political backgrounds, political obstacles. Some countries dealing with their past have done nothing, for example, like Spain or Russia. Communist countries handled it very differently. Also, Latin American countries, after having overcome their dictatorships, handled it very differently. Argentina, for example, had 3 different phases. First, quite early, they tried some of their highest military officers. Then they entered a period of neglect, blindness, followed by a third phase of justice and reconciliation. Chile, also only very late tried its military dictators, and actually it needed a Spanish judge who followed the universal jurisdiction and then brought Pinochet under house arrest in London for over a year. And after Pinochet returned, the Chilean government thought, okay, we have to do something about that. Then you have the Truth Commission in South Africa, and Germany also went through very different phases. Germany, a pretty unique example, because in 60 years they had to deal with 2 different pasts and 2 different kinds of dictatorships. Legally, it was very hard to bring people to court. We were very late, but maybe in the whole transitional justice period, dealing with the past, education, reconciliation, we have done a better job. There are threats from outside and inside to the legal system, and there are threats and impediments. Some lie within the system. The ICC relies on the Security Council, and as we have heard yesterday, the veto powers often are interfering or not going along, and we've discussed the case of Syria. So the ICC was not created by the big powers, but it's heavily influenced by the big powers. Then you have a lack of cooperation by member states. What you could have observed in the case of Kenya, that the court did not get enough evidence, and then the case was closed. Then you have also other threats that member countries of the ICC, of the Rome Statute, are threatening to leave the ICC. And you have the constant debate about double standards. Africans feel themselves targeted and say others are not being brought to justice in front of the ICC. One of the biggest dangers, in my opinion, as an outside observer, are illiberal democracies. It's maybe not a short-term effect, but a long-term effect. So what happens if democracies and countries that have incorporated the rule of law distance themselves from those very elementary principles? And I think we cannot yet measure those consequences, what that means in the long term. And then you have also threats from within. You have inefficiency in the court, long trials, complicated procedures. What you can actually observe also here at the ICC, you have only 4 convictions in 15 years. Then you also have scandals that undermine the credibility. You know about the case of Luis Moreno Ocampo, who was chief prosecutor. Courts, and especially international criminal justice system, depends on credibility and on trust and on impartiality. And both, and all 3, are being undermined by internal scandals. So, without further ado, I would like this panel to just first make their own statement, and we start with Dr. Brammertz. Thank you.
Well, we are speaking about international criminal justice and politics, which is a quite obvious reality, because as long as there is no universal judicial system, politics will play a key role. And for those of us who have worked in a national system and international system, this is the main difference. As chief of a Belgian prosecution office, well, I was mainly cooperating internationally with Ministry of Justice and Ministries of Interior. Since I'm working as international prosecutor, our counterparts are always the Ministries of Foreign Affairs, which, by the way, is one of the big problems we are having, I think, at the international level, is that Ministers of Interior and Justice very often are not giving the necessary support by releasing people to international tribunals because they don't consider it as their business. So every time I have the opportunity to speak to Ministers of Interiors or to Chief of Police of national systems, I'm always explaining that, well, if we call crimes against humanity, it's because they should be of concern to everyone. So please, national systems, support us. This would be an interesting topic for another conference. We have already discussed that we have seen over the last years that the support for international criminal justice has been very, very different over time. If we look back to the creation of the ICTY and ICTR, and of course we all know the positive and more negative elements about it, but reality is that since the creation of the ad hoc tribunals, there's never been another judicial international institutions put in place with the same power, created by the Security Council, based on Chapter 7, obligation to cooperate, for all states, primacy over national jurisdictions. We haven't seen this later on in all the other initiatives which have been launched in relation to the hybrid tribunals. We have seen that very often it is the political leadership of the moment who have a major impact on the creation or not of a tribunal. Having been myself involved in the investigation commission in Lebanon, it was quite obvious that the creation of the tribunal was very much also the result of having Chirac and Bush being very much personally involved in following the peace process in the region and pushing very, very hard. I mean, we have here the freshly appointed chief prosecutor of the Kosovo tribunal. Well, one could argue that it is very much the result of starting point book from Carla Del Ponte, investigation commission, Marty investigation commission. It started with a lot of conspiracy theories about organ trafficking, and well, the result is a tribunal which has a very specific mandate. But again, expectations are not necessarily what is feasible afterwards. And we discussed about the situation in Syria, where I think we're all in agreement that it's not really a situation where the international community can be very proud on how it has been handled, and the political problems are, as always, in the center. We all know that it's a conflict already 3 times more victims than the conflict in the former Yugoslavia, already taking twice as long. And what do we see today? Well, for a number of years now, an investigation commission at the level of the Human Rights Council, with Carla Del Ponte resigning very recently, as we know, with very limited possibilities on the ground. You remember all the GIM, which has been created, this investigation commission looking into the use of chemical weapons, where the first mandate was to determine if chemical weapons have been used, but not to decide or to give any information about who the alleged responsible is. Well, we had more recently the decision by the General Assembly to put in place the Syria mechanism, and of course we applaud and support this as an initiative, but we have seen immediately that a number of countries, especially Russia, saying, well, this is an illegal investigation commission because the General Assembly, according to their legal analysis, has not the authority to put up a judicial system. And when I saw the first organigram of the Syria mechanism, well, investigators were not called investigators, but information collectors, because the mandate is not to investigate, but to analyze existing information and to collect existing information. So my point is very much that many tribunals, investigation commissions, fact-finding missions, their success or possible success is already very much influenced by the limited mandate, the limited possibilities, the limited resources, and some persons would even say that this is part of the intention behind. So I really wanted to say that there is a weakness very often already integrated into the system, and it is, and I'm now speaking, I think, on behalf of many colleagues dealing with tribunals, investigation commissions, fact-finding missions, that very often the same international community which come up with the compromise to create a mechanism is very often also the one criticizing later on if the results are not as they should be. I want to say a few words about what are the lessons learned in relation to our tribunal when it's about political interference. And as it is the oldest one, it's quite interesting to see how political support and political interference really changed over time if we look at the last 25 years. Many of you were involved in the creation of the ICTY, and I remember when we had Madeleine Albright a few years ago in The Hague. She was speaking about it, about how important it was for her and for everyone to create the ICTY, but that the expectation at that time were very low, that no one would have expected at that time that the tribunal would really one day be established, and she said at that time she would never had imagined that one day all the major individuals would have been arrested and put before the judges. And we, if we look then over time, my predecessors, the first prosecutors, really had very difficulties in getting cooperation in the former Yugoslavia, not only because many of the persons indicted at that time in the 90s were still in power, but also because the international community was much less committed to be supportive. We have a number of situations in our cases where we can see that Karadzic or Mladic were seen by members of the international community, peacekeepers, but who were not arresting because they were considering that an arrest would be against their key mandate, which is peacekeeping, which is something we see very much in more recent conflicts where you have this dilemma between accountability and peacekeeping. We have seen later on that the situation changed with political pressure. We have seen it later on with the arrest of Milosevic, where it was basically the US saying, well, a few days before donor conference, if Milosevic is not arrested and surrendered, well, there is an important amount of money which will not be given to Serbia. So it was very much political pressure which brought results. And during my time, I've seen that the most important political tool has been the so-called conditionality policy, where the European Commission was imposing on the countries of the former Yugoslavia to cooperate with our countries if they wanted to move to the next level. And I'm personally absolutely convinced that if there would not have been the pressure from the European member states, even today Karadzic and Mladic would not face justice, and we would not have next month, as you know, probably the judgment in relation to the Mladic case. So this has been very instrumental, and again, it is quite surprising for a prosecutor who is coming from the national system to report to the Security Council every 6 months about progress in investigations. But over the last 5 years, we have also done it, especially before the arrest of Karadzic and Mladic, in Brussels. So it was quite surprising for me as a chief prosecutor to give briefings to the 27 ministers of foreign affairs about the quality of cooperation, and it was then up to the political level to decide to move forward or to move forward in terms of EU enlargement. So, and it's a tricky line where, as a prosecutor, you just make the assessment about the quality and the quantity of cooperation, and it's up to others to give political importance to it. And then we are today in a different phase, where all the fugitives have been arrested, where there are many other conflicts which are in the news, where we see that the European Union is fighting with other problems, the immigration crisis, the problems in Kosovo and others, and where, in fact, fighting for justice in the former Yugoslavia is not anymore the key priorities. Those of you who are a little bit following the development over the last 2 years, and we are really very much concerned in this regard. Remember when last year the Karadzic judgment came out, the day before, in Republika Srpska, a university building was called after Radovan Karadzic. A few months ago, the Minister of Education in Bosnia-Herzegovina said, well, we will ban out of our school books all reference to the siege of Sarajevo and the genocide of Srebrenica. Why? Because it never happened. And not later than this week, there was a big conference of current and former military officers in Belgrade, where some of our convicted generals, after having served their sentence, are now back in the country, where this week the Minister of Defense of the Republic of Serbia saying, well, there is no reason anymore to be ashamed for what has been done in the past. And I quote, you are the greatest among the greatest. And not later than yesterday, two of the convicted generals for war crimes and crimes against humanity were appointed teachers at the military academy with the message that, well, you are the real guys, you know how it works, and every military academy in the world should be proud to have someone like you coming to teach. So my point here is that international criminal justice is only as strong as the political will to see it being successful. If our tribunal is today the only one with no fugitives at large, it's because there have been a number of years where the international community was speaking with one voice to make sure that it was successful. We see today that the support is a little bit different and priorities are different, and the devils of the past are very much coming back. And I really would like to conclude on this part by quoting one of the historians who wrote an article yesterday in a Croatian paper, who was really saying that one of the big problems is that people are looking all the time to the past because they have no vision for the future. And a last word perhaps, and then I see my 10 minutes are over. We spoke about the fact if international criminal justice has today more support than years ago. And the peace versus justice issue, I think we discussed it 200,000 times, and everyone here in the room probably is convinced about it. But over the last year, I had the privilege of giving a number of lectures, or to students, or to future magistrates, or to future diplomats. And I was always asking the question, if by giving immunity to the leaders of the different groups in Syria, we would end the conflict, and from tomorrow on, no one would lose his or her life anymore. Would you be willing to give a full amnesty and safe haven to these individuals? And I was, in fact, not surprised to see that it was 50%, not more, who were of the opinion that accountability could not be negotiated. And this, I think, is the reality today. It was discussed yesterday as well. Reality is that the fight for accountability is for all of us a priority, but my understanding is, of having discussed with colleagues who are involved in the peace negotiations in Syria, it is not really high on the political agenda, and we should be worried about it. Thank you very much.
Thank you so much. And the irony of history is that Karadžic's daughter is now a very influential politician in Bosnia-Herzegovina, and people say she's even one of the more sensitive ones, which is even more ironical. So, Mrs. Moreno, you are deeply involved in the peace process in Colombia, and we would like to learn from your insight, and if you also may also answer the question whether the referendum and asking people and letting people participate at the final decision is an impediment, or is it actually giving support to the peace process?
Thank you, Martin. Thank you so much to the Academy for the invitation. It's an honor for me to be here and to participate in this panel. I would like to present the main challenges of the transitional justice process in a divided society as the Colombian ones today. Transitional justice processes confront massive violation in fragile conditions where the justice system and protection of rights have significantly or totally failed, which means that the scale alone cannot be addressed by the normal civil or criminal remedies. Here, fragility can refer to a broad range of factors, including weak institutions, political instability, corruption, few financial resources, and lack of civil society organization. Transitional justice is now seen to be an important element of the international community's post-conflict reconstruction and peace-building agenda. The nature and scale of the horizontal violation committed during armed conflict, that is, between citizens and groups, is different in important ways from the vertical violence that may be more prevalent under authoritarian state, that is, violence committed by the state against its citizens. If transitional justice is understood to be an important long-term peace-building strategy, then the place where it is likely to have the greatest potential influence is in preventing conflicts that are otherwise likely to recur. While most conflict prevention focuses on the short term, the frequency of conflict recurrence suggests a greater focus on post-conflict settlement, and transitional justice may play a more productive role in reducing recurrence. Perhaps one of the most dramatic and frequently invisible impacts of the long-standing internal armed conflict is the lack of trust within the population and between citizens and the state. In many cases, the state is viewed as the enemy and has lost all legitimacy in the eyes of its citizens for not having prevented the atrocities that occurred. These perceptions create the temptation, which often materializes in concrete action, to resolve conflict by non-legal means and seek alternative and illegal ways to obtain what the state is unable to provide or guarantee. This mistrust, in turn, produces deep division within society. There is distrust on all sides, and the political discourse becomes polarized, with a tendency towards radicalized positions that sector of society engage with emotionally, often without prior critical reflection. This is the case of Colombia, my country. As you know, the government of Colombia and the FARC guerrillas signed a peace agreement on November 24, 2016. After more than 5 years of negotiation and a plebiscite on the agreement that lost by a slight margin. The initial phase of implementation began immediately and has proven more difficult than either negotiating party anticipated. The problems and challenges to implementation are due in large part to lack of consensus within society about peace, even after the signing of the peace agreement and the disarmament of FARC. Broad sectors of society continue to believe that the only possible legitimate outcome was the military defeat of the guerrillas, and the peace agreement is a breach of the rule of law. The issue that generated the most resistance and criticism by these sectors is justice. The transitional justice model designed by FARC and government is perceived as impunity. Other society sectors that support the peace process and voted yes in the plebiscite understand the need to make some concession to end 50 years of internal armed conflict. For example, handing down sanctions that do not involve jail time in exchange for the complete truth about the crimes committed during the conflict does not mean that there will be impunity. This justice model, known as the Special Jurisdiction for Peace, is a component of the comprehensive system of truth, justice, reparation, and guarantee of non-recurrence agreed by the government and FARC to guarantee the right of victims of human rights violations and breaches of international humanitarian law, and guarantee a legal certainty for those who participated in the internal armed conflict. The effectiveness of the Special Jurisdiction for Peace should not be limited to a consideration of the numerous technical and legal issues that will need to be addressed and resolved to start up the jurisdiction, and that will certainly persist over time. Indeed, the victim's future perception and evaluation of the work and result of the Special Jurisdiction for Peace will not depend on technical issues, the norms that created, or the difficulties faced by the parties in reaching the agreement. Instead, their evaluation will concern the effectiveness of the Special Jurisdiction for Peace in the materialization of the rights, the authenticity, transparency, and celerity of the process, and in the legitimacy of its sanctions and their effective enforcement. In other words, what is really at stake here is the credibility of the peace agreement and its capacity to rebuild citizens' trust in justice. One of the most innovative aspects of the peace negotiation between the government and FARC was the participation of victims in the process, both in Havana and in the country. Significantly, most victims have been more willing than other sectors of society to accept the possibility to achieving an adequate balance between the superior objective of peace to avoid future victims and the accountability of all actors to the armed conflict. Both in Havana and in Colombia, the victims have demonstrated their generosity and willingness to dialogue with their perpetrators without renouncing their rights to truth, justice, and reparation. In contrast, other sectors of Colombian society not only believe that former FARC combatants should go to jail, they also believe that until they do, any dialogue with them is invalid and they should not participate in politics. As mentioned before, the deeply polarized environment that surrounds the peace process has made it difficult to implement the peace agreements, especially the development of the implementing legislation that provides the legal basis for the measures agreed by the parties to the conflict. The startup of the Special Jurisdiction for Peace depends on a statutory law that elaborates on the constitutional reform and on the rule of procedures that will be formulated by the magistrate and approved by Congress. These steps must be taken before the end of the year. However, given the slow pace of Congress linked to the beginning of the electoral campaigns and the complex administrative process of creating new state institutions, it is very possible that the Special Jurisdiction for Peace will not effectively begin until the first half of 2018. The delays in the implementation of the different mechanisms of the comprehensive system, especially the Special Jurisdiction for Peace, will certainly deepen the existing distrust of several society sectors in the process. A fundamental element of the comprehensive system is truth. The judicial truth that the Special Jurisdiction for Peace will produce should be complemented with the extrajudicial truth produced by the Truth Commission, and by the information that will allow the thousands of people who disappeared during the armed conflict to be found. The system should also guarantee that those responsible for serious rights violations, crimes against humanity, and war crimes are held accountable to the victims and to the society and receive sanctions. These measures should serve as the basis for the undertaking the path of a reconciliation and coexistence, which in Colombia will most certainly take more than one generation. Of course, we still need to ask whether the transitional justice measure will be sufficient to achieve these objectives in such profoundly divided society with very high levels of exclusion and inequality. Potentially, more important for reconciliation than the result of transitional justice mechanisms, however, are the process through which those mechanisms come about, the environment in which they are discussed, the decisions through which they are shaped, and their participatory nature. At the same time, transitional justice processes can in some cases foster rather than overcome divisions, especially if they are seen as lacking legitimacy or impartiality. This is most likely to be the case if they are inappropriate for the context of if they lack transparency or victims or public participation. But the situation in Colombia is not all negative. Despite the depolarization of the public debate, significant changes are taking place in the country, which can be felt especially by those who live in the regions. The population feel more secure, and their lives have slowly begun to normal. In the cities, people are becoming used to public appearances by former FARC commanders, for example. For example, thousands of people attended the inauguration of their political party a few months ago. And there have been other positive changes that fill us with certain optimism. An agreement on bilateral ceasefire, an end of hostilities reached a few days ago between the government and the ELN guerrillas, the second largest guerrilla organization in Colombia, the acts of recognition of responsibility carried out by the FARC with groups of their victims, and the Pact for Truth and acknowledgement of responsibility between two historic adversaries, the FARC and former paramilitaries of the United Self-Defense Forces for Colombia. Finally, I would like to end with a quote by a former FARC combatant. "The truth can give us the strength to accept one another." Thank you.
Thank you so much for your very valuable insights. Mrs. Molokome, please. You have the floor now.
Thank you very much, Moderator, and good morning, Excellencies, colleagues. Well, thank you. I think like everybody else, I really do appreciate the opportunity to be here with all of you and to join the Nuremberg Academy in this annual reflection on where we are, I think, insofar as our attempts to make the world a better place, basically, through that contribution to international criminal justice systems. I was introduced in a very glowing fashion, as were my two colleagues. I hope by now you've forgotten, because then your expectations might be a little bit too high. But I am here in my capacity as a member of the Nuremberg Advisory Council. I wear many hats. I'm a representative of my country to the UN and Switzerland in Geneva. I'm a member of AGJA. I'm all sorts of things. But I will have no disclaimer, though, because many of my views coincide with those of my government, which I represent. And I think for those of you who know Botswana know that it's not very difficult to represent Botswana in this particular area of your freedom. Your human rights are guaranteed. Generally, certainly, yeah, yes, if you know them. I think that the good thing about speaking on day 2 and on a Saturday morning like this is that I think much of the ground has been covered, and I think I want to thank, in particular, the opening session and the presentation by Navi, the two Davids and so on, very broad brush that really shows what the issues are. And since we've been asked to address the political impediments, once again, I think what Serge did and my colleague next to me here in the specific case of Colombia is very helpful in setting the stage to a discussion about politics. Because in a way, we have been talking about political impediments for the past 2 days. But I do think that the whole power imbalances, geopolitical interest, and so on issue is important to keep in mind as we discuss, as we reflect on 10 years of the Nuremberg Declaration, on the Rome Statute, and so on. I've been asked to speak specifically on the Rome Statute and regional politics. I think we will all know and agree by now that the impediments that have presented themselves to the implementation of the Rome Statute, especially in the Africa region, on which I will focus, I'm sure that's what you expect, are intimately linked to, and in some, as some Africans will say, they're a direct result of the pursuit of political self-interest and geopolitical power imbalances that prevail at the UN. I think that one is a fact. The Rome Statute, of course, we all agree that the Rome Statute, even with its imperfections, that created the ICC, with its imperfections too. I mean, the President admitted to us yesterday, and I found it really very good of her to be modest about it and to say, yes, we have problems, but it's still a good project. But we all agree, as I said, that it presented a watershed in our quest to end impunity and bring perpetrators of the most serious crimes to justice. I think otherwise we would not have had the opportunity 10 years ago to draft a Nuremberg Declaration without that backdrop and that framework that was created by the Rome Statute. I think a further complication we all know by now, and that has been discussed so far, is the fact that the Rome Statute, it has some kind of a design error. I like to say this, but it's not meant to be, it's actually meant to be complementary and sympathetic to the ICC in the sense that, as Serge said, unlike domestic courts, the Rome Statute created a court that is not purely judicial, it's a quasi-judicial court. The fact that you don't only get a case to the ICC because someone reported it and the prosecutor went to investigate, there is a political route through the UN Security Council. What complicates it even further, as you all know also, is that in the Security Council are big countries, powerful countries that are not signatories to the Rome Statute. So there is definitely, I don't want to say it was doomed to be political, but I would say it was somehow designed, whether deliberately or not, to be a political process, and I don't think we should be too surprised about that. I think talking about Africa really, we can also recall that the relationship between Africa and the Rome Statute started really well. As we all know, the African group of countries is the largest bloc remains the largest bloc. Despite all the memorandums of withdrawal, you referred to withdrawal and so on, we are still the largest bloc of, regional bloc of countries that are signatories to the Rome Statute. In our Constitutive Act of the African Union, the end of impunity is one of our clear goals and our aspirations. So, like Hillary asks in her recent book, what happened to this love affair between the ICC and Africa or the AU? I think we also all know what happened. I think it began to break down, as we will recall, with the indictment of the Sudanese president, President al-Bashir, in the late 2000s, followed by the indictment of Uhuru Kenyatta of Kenya and his deputy. The perception, and I want to underline it is a perception, because the position of my country is that, in fact, this is not reality. The perception of selective justice, which is that the ICC was targeting Africa, African leaders, and so on, ignoring atrocities elsewhere in the world. Of course, atrocities elsewhere in the world, the ICC has ignored. But are we going to say that the countries where the ICC is busy in Africa, there are no atrocities? Of course, there are atrocities. And I think as Africans, we should be the first to accept that. As I said, my country does not share that perception in any case, and we've always made it clear that just because, things are going wrong elsewhere, we should not say they are not going wrong in our own backyard. I think we also all know about all the resolutions, the 2013 resolution. I think, Navi, you referred to that yesterday, where the African Union decided that there would be no cooperation with the ICC, even those members of the African Union who are members of the Rome Statute should not cooperate with the ICC because the ICC was being selective, that this undermined peace and so on, the pursuit of justice. I think that whole story we know. Once again, my own country, Botswana, did not subscribe to that. And I think we were a little isolated in this regard, but sometimes it's better to be comfortable in your isolation, knowing what you stand for and knowing that you are on the right side of history, even if you suffer for it in many other respects that I will not share with you now. Isolation is not a good thing. Of course, the AU felt vindicated after the collapse of the Kenyatta and Ruto cases. The whole perception that there was this conspiracy against Africa and against African leaders was strengthened at this time. And I must say that there were certain things that were happening in some Western countries that reflected some, sinister motive as far as some of our African colleagues were concerned, of regime change. And I think when we talk about these things, we need to be open and transparent so that when some African countries are feeling this way, we should admit that you do see certain signs, certain things that are being said, the court being treated in a certain way, being approached in a certain way that can lead to these suspicions and perceptions. I think you know that in January 2016, the AU then put together a ministerial committee, set up a ministerial committee to inform action by AU member states on the so-called withdrawal strategy. We, of course, and a few other countries, I think Senegal was one of them in the AU, but we took the position that we joined the Rome Statute alone. We are not going to be living with a whole group of people, and we didn't think that in international law anyway there was any such thing as collective withdrawal. That paper, I think, is somewhere gathering dust on the shelves, and it has not been revived, but there is a paper, a document, which was drafted by this committee, which describes the process through which this purported collective withdrawal could take place. I think it has become quite obvious that a collective withdrawal is a bit of a red herring in this respect. But let me talk just briefly about withdrawal because you raised it, Martin. I think memorandums of withdrawal had already started when South Africa failed, the government failed to arrest the president of Sudan when he came to South Africa in 2015. There was a successful court challenge by an NGO, Southern African Litigation Society. I think the young lady, Angela, she's sitting here somewhere. I always praise her for this. She was very brave, a very small frame, but a lot of energy and courage. She, from the Southern African, she was the chief litigator in the al-Bashir case. And they brought this case in a very courageous way before the courts in South Africa, and the courts in South Africa came to the conclusion, they succeeded, that the government should have done, so that they acted illegally in violation of their commitments, international commitments under the Rome Statute. The South African government, you will recall, reacted immediately by announcing they would leave. As we know, they have not left, not because they don't want to leave, but because another court, approached by another group of NGOs together with the SALC, decided that such withdrawal was also illegal. The bill that was presented before Parliament by the Minister of Justice, as you know, was also eventually withdrawn, if my information is correct. The notice of withdrawal that was sent to the UN has to be withdrawn because, and I think you can confirm this, Navi, because the South African government, like my government, even when they don't like it, they do respect court decisions, and the courts in South Africa are independent in this regard. So we thank God for that. Things are now very quiet in South Africa. And as you were saying, Serge, accountability, criminal justice, and so on, these are not priority at the moment. The South African government has other issues, domestic issues that they are dealing with. Burundi, just very quickly, before I run out of time, I think we all know that the story of Burundi coincided, like the South African story. They began to talk about withdrawing when it was announced that in April 2016 that a preliminary examination would begin into the violence and horrible atrocities that were happening in that country. He quickly passed legislation withdrawing Burundi's membership of the Rome Statute. The notice of withdrawal was deposited with the UN. According to the Rome Statute, next week, on the 27th of October, is when the Burundi withdrawal will become effective. I'm looking, we are all waiting with bated breath to see. I think it's going to take effect. I was involved in the recent Human Rights Council session that took place in September, and I can tell you that the Burundi government was extremely hostile towards the Commission of Inquiry. They rejected it. They wrote to many of us saying we should join them in the rejection. We didn't. And we don't plan to, because we believe that we must respect mandate holders of the UN, of the Human Rights Council. It's our creation. Burundi is a member of the Human Rights Council, and I think we need to be exemplary in this regard. So, unless they withdraw the notice of withdrawal, it seems that they will momentarily, temporarily escape from their obligations under the Rome Statute next week or so. But I don't think that they should think that this will be the end of the story. Gambia, I think we know about Gambia. The Gambia story ended well. It was the third African country to announce its intention to withdraw from the Rome Statute, but as we all know, it never materialized due to the loss of the election by the longtime president, a strong man, and his eventual dramatic departure into exile after a failed attempt to remain in power. Lessons, very quickly. What can we learn from these the lessons? I think very positive lessons, in my view. The South African experience for me, and I will never stop saying this, and I know South Africans who are more critical of their country than I am will say that I shouldn't overpraise them, but I think that your civil society in South Africa is an excellent example of what can be done when governments do not respect the rule of law and when they want to escape their international obligations without cause. I think that the importance of an independent judiciary in the case of South Africa as well, is very important for ensuring accountability. It was again demonstrated in Kenya. We can all be very proud of the judiciary in Kenya. I'm not saying that I was happy that the election result was annulled. I'm just saying that for a judiciary to be that independent and courageous in that context is something that we as Africans and as international lawyers should celebrate. I think the dramatic turn of events that are referred to in the Gambia also reflect how quickly people who have been galvanized into action by civil society organizations and opposition parties and so on who come together can respond to a situation or rise to the occasion when they are given the opportunity to assert their democratic rights to elect a government and so on. So I think all this, and especially what happened in South Africa and the Gambia, must have dampened the AU's energy to say that there was going to be this collective withdrawal. So I don't think there is an exodus. I think the AU also has other priorities at the moment, more pressing issues, and I think that talking about politics, we should also act like other regions. We should begin also to be political. Look, focus on what needs to be done. Some of the questions Dr. Pile there asked about the flows, financial flows, and so on, and begin to engage on a world level on these issues rather than focus on being victims and being selected, because there is a huge agenda out there, and I think the SDGs clearly say that there is that framework which we can all work on. Let me end, Mr. Moderator, because I'm sure I have 1 minute left. Or is it 2?
30 seconds.
Let me end by saying that really I have talked about how useful and important civil society organizations are and so on. I think that the Nuremberg Academy, this annual forum, plays a very important role in providing a platform for sharing ideas and best practices. And I know that there are other events that the Nuremberg Academy does, and I think these are complemented by many others who have experience in working on capacity building at a practical level. In the Africa region in particular, there are many. I think you did say, Marike, that we need to be very conscious. We need to make sure that we know what's going on in many countries on the ground. And I think many of you who made presentations here and who are engaged at the domestic level know that there's a lot of expertise. In particular, in the Africa region, there is a lot of expertise of local civil society organizations, lawyers of all sorts of specializations that work on these issues. And I think that collaboration with these institutions is very important. I think we do have organizations. I'll give Wayamo as an example. I see Bettina sitting over there, the Africa Group for Justice and Accountability. I can tell you one of the things that that group is doing. Some of us belong to both, AGJA and the International Nuremberg Academy, and I think that is a good thing. There is a delegation that's going to the Gambia, because the Chief Justice of the Gambia is a member of the AGJA, where he now has asked for assistance in capacity building and so on in moving the Gambia forward after these dramatic events that have taken place. I think that there are many others that I have not mentioned. Africa Legal Aid, I think those of you who are based in The Hague, you know Evelyn Ankuma, who works in this area. And I think that working together and making sure we don't duplicate the work that others are doing, because that is wasteful, making sure that we fill in gaps and we don't compete with each other because resources are limited, then we can, I think, move forward and deal with these political impediments, which, as I said, we should have expected anyway, and they are not always a bad thing. Thank you very much.
Thank you. Thank you very much for these great remarks. Before I open it up to the public here, I would like to throw two questions into this round. And the first one is addressing Mrs. Molokome and Mr. Brammertz. It is, do you think that in order to crack the chains that bind the international courts, that the principle of universality, or the universal justice, what we see more and more coming in countries like Germany, France, Sweden, that they put on trial perpetrators, and you have the first Syrian cases, others will follow, so that they actually can circumvent with this principle some of the burdens that international courts, are bind of them. And do you actually, and what actually has to be done to make international courts more efficient? I'm referring to the Lebanon case. They have been dealing with this for years and years, and nothing has happened, except that they have spent 6 million euros. And to put it frankly. And Mrs. Moreno, what do you think, when you look at the Colombian peace process, it will probably, the luck of this process will depend on also the participation, political participation, and economic participation of the FARC. And then on the other hand, you have people that just, accuse your negotiations because they think, okay, it delivers too much impunity to some of the FARC members. And do you think this process could be actually endangered by the next elections? So this is just, I would like you to just briefly answer this question in 1 to 2 minutes, and then I open it up to the public to your questions. Thank you so much.
Well, universal jurisdiction. We have in Belgium, of course, a history on universal jurisdiction. In 1999, I remember very well, I was the chief prosecutor then, where unanimously our parliament, first one in the world, voted in favor of universal jurisdiction, and 3 weeks later we started to get cases from around the world, creating a lot of problems, including in relation to the Iraq War. We had cases, Bush, Powell, Cheney, Rumsfeld, Sharon, and many other important cases. And it was, of course, immediately a problem in terms of operational capabilities. So Belgium, how would we be able to do it? But a lot of political pressure coming, especially also from the US, to have this legislation changed, and it was changed twice. So I would say in a perfect world, it is, of course, the solution, because if you would have universal jurisdiction, there would be no need for international tribunals to come in. We have seen that, I'm coming back to the former Yugoslavia, it is a big discussion there, because you have a number of arrest warrants in Serbia in relation to Croatians, in Croatia in relation to Serbs, some of them most likely politically motivated, and so you have to be very careful that in some countries it's not becoming a political tool to prosecute individuals more for political reasons than for real ones. But of course, in principle, universal jurisdiction is a very, very important one. Second question, very briefly, you mentioned the Lebanon Tribunal, and I think this is one of the typical dilemmas. As I mentioned, I was 2 years in charge of the Hariri Investigation Commission, and I remember at diplomatic briefings the discussion about, is it the right moment to create a tribunal, yes or no? My answer was at that time, well, if you are looking to create a tribunal because you have a case, well, there is no need to create a tribunal now because we have no case yet. If for you the simple existence of the Lebanon Tribunal is already 51% of the objective you are looking for, well, do it. And the answer was, well, the existence of the Lebanon Tribunal as such is already a very important, is our main political objective, because in the fight against impunity in a region where political assassinations have been the rule, well, this is a very important sign. But the same international community, who is, of course, is financing the tribunal, is today saying, well, it is taking too long. And this is what I'm saying, where the politics is coming in. The creation of the tribunal was really very political, and I think not necessarily wrong decision, but the criticism is not always really justified, because, as I said, the tribunal was created at a moment where the investigation was still very much ongoing. So it's always a question of management of expectations, and my colleague and friend David Schwendemann, who is now the new prosecutor for the Kosovo Tribunal, where everything is a question of management of expectations. We discussed it many times before. If you go to the Serbian side, they would say, well, 300 Serbs disappeared and their organs have been taken. Now, I'm sure our colleagues will do an important job, and we are very, very supportive. But to meet those expectations will be almost mission impossible. That's why I don't always accept the criticism in relation to saying, well, international justice is expensive, but not very efficient.
Thank you. Mrs. Molokome, please.
I think what I can add to Serge's very, I believe, adequate answer is that universal jurisdiction, yes, is the ideal, but in fact, the whole setup of the Rome Statute and the ICC is that it would be nice, yes, to have universal jurisdiction. We don't, but built into the mechanisms of the Rome Statute is the complementarity idea, which is that, in fact, only cases which cannot be prosecuted at domestic level will end up. That was the idea. That is the ideal. It didn't work. And I agree with you, Serge, that we should not measure success or whatever of the international systems against how many convictions, how much money we spend, because in the final analysis, I don't think it's always about numbers. I think it's about the message, it's about the moral value of what we are doing, and hopefully the deterrent value, although we have no guarantee. To respond specifically, Martin, to the other, mechanisms, I would say that the complementarity requires that we build capacity at the national level. That is why JRR, Wayamo, and a host of other organizations are trying to assist at the domestic level, train judges in specialized methods of investigation, prosecutions, training judges to listen out, to look out and to know about international criminal law, because most judges in our countries, they deal on a daily basis with your domestic crimes and situations. But also, most importantly, I think the regional courts Africa is trying to come up with an African court. We're having some problems. It doesn't quite come into effect. Yes, also we're talking about the expense of it and so on. So I think it would be good if we could have these regions. And I think the ICC could then play a background role. But in the meantime, it can't sit back and say that we are waiting for the domestic jurisdictions to prosecute and for the Africa Regional Court to get organized. I think an excellent example of an African solution to an African problem, which is what we love to say, is an Abre matter. If we can do more of those, I think that we will see. I think there are many people in the audience here who can give us other examples of the war crimes divisions. I think in Uganda, is that what it's called? I think the Kenyans have something. Even as we think Kenya is fighting with the ICC, or Uganda is not, Uganda is cooperating very well with the ICC. So some of these things, I think they are happening. It's just that we hear of the big problems, the failures apparently of the ICC, just because the problem is so big. I hope I tried my best to answer some of what you asked. Thanks.
As a journalist, I could add something to that, but I won't do that now. Please, Mrs. Moreno.
Well, political participation is in fact one of the most discussed issues during the negotiation, and currently in the country is still under discussion, because the Constitutional Court have to decide in a few weeks about or if the political participation is according to our constitution, and if it is possible for FARC to have at the same time the restorative sanction or the ordinary sanctions, and at the same time participate in politics. So we are waiting for this final decision. But of course, one of the main challenges of the implementation process of the agreement is the next election. As you know, next year we will have a new government. We will have election on May, and there is an important possibility to have a president of the extreme right wing for the next 4 years. Is a possibility. Of course, we have to wait the elections, but there is a trend in Colombia to have this kind of new government. In that case, of course, there is a risk for the agreement, but it's a relative risk, because if they want to go back to the situation and to end the process, they have to again to present a constitutional reform or amendment that have to be approved in the Congress, or they have to pass a plebiscite or a referendum in order to ask for people if they want to back to the previous situation. So it's not so easy. But of course, the lack of political will in a new government could make more difficult the implementation of the agreement, because the new government can decide, for example, not to put money or finance the different mechanisms agreed by the parties to the conflict.
Thank you, so we keep our fingers crossed. Ladies and gentlemen, the floor is yours. The lady on the left.
Good morning, everyone. Nicola Palmer from King's College London. My question is actually for Dr. Molokomle, and I think your call for engagement here is a very powerful one, and you obviously picked up on Navi Pile's suggestion around financial flows and financial transparency. But I would be interested in where you're seeing other points of crucial engagement from various African states in the international agenda at the moment.
Thank you. I will collect 2 more questions. Yours, please.
Good morning. My name is Angela Mulukuti. I'm with the Wayama Foundation. Thank you for a very interesting panel. My question is about universal jurisdiction, because my sense is, as far as the ICC and perceptions of bias is going, we are losing that battle because the rhetoric is strong. The ICC is targeting Africa, etc., etc. And I fear on the universal jurisdiction front, we're headed in a similar direction. We see Liberians being tried in Europe, Rwandans being tried in Europe, but as has been mentioned, when it comes to the US and other big powers, these cases don't take place. So my question is, how can we avoid losing that battle on the universal jurisdiction front?
Very good question. Thank you. Please. And then we go for an answering round, and then I'll take the other questions.
Richard Dicker from Human Rights Watch. Indeed, thanks so much for a very engaging and important panel. I want to go back to a point that Serge Brammertz made about the varying political support for international justice and link that to comments made yesterday about the landscape, the environment, that is much different and much less supportive than it was 20 or 15 years ago. I would suggest that is an ugly reality that we have to accept and turn our attention to. There's no running away from it. I think in doing so, it's imperative to look both inside and outside the box, because these times demand new, creative, innovative thinking. And I do have a question. I'm not just here to make a statement, but I think inside the box we have the International Criminal Court. And I think that mechanism exists in a terrain that makes it more needed today than it was in July 1998 because of all the situations of horrific armed conflict, situations where the court does not have jurisdiction. Looking outside the box, and here is my question, I think, as was said yesterday, looking around the Security Council to the General Assembly to step up to the plate in the face of a polarized and paralyzed Security Council. There has been reference to the triple IM mechanism created for Syria. Interestingly, for the Democratic People's Republic of North Korea, the Human Rights Council last year added investigative capacity to its team in Seoul. And the question that I have for all the panelists is really what you see as the potential advances as well as challenges for some of these smaller, newer steps beginning to compile dossiers. And then lastly, on the African Union, a question about the hybrid court for South Sudan. Because if there ever is a challenge that the African Union faces to bring reality to its commitment to accountability, it is moving forward in creating that tribunal. And I'm curious as to what the prospects of that may be.
Thank you. So please, Serge, will you start? And please be brief in your answers that we can make a second round because there are a lot of hands still up.
Well, the difficult one on universal jurisdiction, I unfortunately have to agree, and that's why I was a bit careful in suggesting that it would be the perfect answer, because you would have some countries considered as so-called democracies, which we would have the legitimacy to do it, and others where one would say, well, we don't accept it. One has also to be very realistic. We have seen it in our universal jurisdiction cases. Those in relation to Rwanda are the only ones where we have been successful in the Belgian judicial system, because we had the cooperation from Rwanda, who had obviously their own interest in helping us being successful. But to imagine one single second that Belgium would be able to investigate an American general in relation to crimes committed in Iraq. It's, of course, very, very difficult to imagine. So one has to be realistic in that regard. And this brings me somehow to the question Richard Dickert asked. I think all of us who were at the early days at the ICC and looking at the ICC, we were, at least I speak for myself, very much idealistic believers in international justice, and today we are still believers, but realistic ones. I don't believe anymore that the solution is international criminal justice or the ICC or others are allowing us to have a global solution to all the challenges we are having. We mentioned the Hissan Abre case, which I think it's a very, very interesting one. I believe very much in capacity building and training. We discussed it before with many of the partners here present. We have trained several hundreds of colleagues in the African context, but also elsewhere. So I really think that solutions in the future for any conflicts must always include an international answer where necessary, but a regional or a national where possible. So I believe much more in integrated judicial answers to conflicts than to say, well, the ICC or another tribunal will fix it. And just to finish there, our tribunal will end at the end of the year. 161 individuals indicted. We always like using this figure because it's higher than all the other tribunals together. But what is the reality? Reality is that next week I have meetings in Sarajevo where 5,000 investigations are still ongoing. So it is great what we have achieved, and I'm sure that the major individuals we have indicted and prosecuted and convicted would probably still be in politics if it not had been done 15 years ago. But all the approach of justice delayed, justice denied has to be rethought about because what is difficult today will be possible in 5 years and 10 years, and I believe much more in longer-term solutions where you have this international, regional, and national component somehow integrated, where it is now tried in the Central African Republic, where you have the ICC coming in, where you have now the ad hoc regional solution, and where you will have domestic prosecutions in the classical system as well.
Maria?
I want to add that the following. Colombia is calling the attention of the international community because maybe it's an interesting example of how to deal with the past, thinking outside the box. There is the parties to the negotiation uses the lessons learned of different contexts as an input for the design of the transitional justice model, for example. I have to add as well that the Security Council has an unanimous support to the peace process and to the negotiation. And we have a very successful UN mission for the verification of the ceasefire and the disarmament. And this is an example of how the international community can be very supportive, but at the same time can support the own initiative of the country, looking at different experiences, but at the same time looking for our own model for deal with the past.
It's your one.
Thanks. Just quickly, I won't answer all the questions that were asked. I think Serge dealt with the universal jurisdiction question. I think Angela knows the answer to this question. She's just putting us on the spot, but we can engage on it further. Let me answer the question about other areas or arenas of engagement. And I think my answer is going to reflect what I'm busy doing at the moment, which is that I'm also accredited to the World Trade Organization, to WIPO, and a few other agencies that are based in Geneva. And I was saying that, we have been quite busy on the Human Rights Council. Botswana is not going to be a member. Of 6 years now will have passed. and we're going to become an observer state. We'll still be engaged. As I said to them, we will be even more critical as observers than we were as members. But I think that the trade and investment issues, very, very critical. And I think the AU is trying these days, in the past couple of years, to look at the trade investment issues, and I think the financial flow issues, the intellectual property issues are big. I think that we need, as African countries, at domestic and at regional level, to begin to deal with those, because they are actually where the human rights of the right to food and shelter and good education and so on, they are embedded in those, so you are able to create employment, make sure that young people can make a living and you can improve the quality of life of your people. And Angela, I don't dodge your question completely. I think that we just have to focus on strengthening the rule of law at domestic and regional level, because we are not in control of this other stuff. I'm sorry to call it stuff, because it's tough. And I think we need, and I agree, Serge, that we have to have that integrated approach. And I'm not an advocate for saying, leave us alone, we're Africans, we're Botswana, we know everything. We don't. And the West doesn't know everything either, because they don't understand what we are doing in our country. So the integrated approach is very, very important. I think that in the final analysis, it is up to each and every country, each and every citizen of our countries, wherever we find ourselves, to invest in strengthening the rule of law, in remembering the SDGs, that framework, as the minimum, the basic framework around which we should really be looking at the whole development framework. I will stop there. Richard, oh dear, the box. Outside the box is a hard place to be. I think there is also talk, from what I'm hearing, and I'm new in this, I'm not so engaged in it, about empowering the GA a bit more. I think even ambassadors who are supposed to be very diplomatic are becoming a little bit louder on this issue of the Security Council, and how in action they are accused, they are guilty of omission sometimes rather than commission in this area, and it is felt that perhaps the GA should really rise to the occasion, and that the GA needs to assert its authority more. But that is an area, as I say, I'm new to, I can't really delve into. Thank you. South Sudan, Betty is here. I'm going to delegate that question to Betty. Betty Murungi, she's the expert on many things, including South Sudan. I don't want to answer and be inaccurate, because she knows better. Okay, thank you.
Thank you. I'm glad that you also answered Angela's question. Please, last round, and with the permission of the organizers, we will extend by 5 minutes. But there was 1, 2, and 3 questions. Please, you first. Brief, please.
Very brief. Philipp Ambach, ICC. I just want to connect a couple of dots and then ask a very old question again. Dots first, we talked about development, that development is something that needs to go alongside with justice. We talked about thinking outside the box in terms of the systems that we have, in particular the Rome Statute system. Serge talked about, and Atalia just picked up on it again, integrated approach. These are dots that we had also during the last 2 days, and here comes the old question. Should we then not maybe think outside of the box in the current geopolitical context, that we maybe add something to the ICC mandate, and that would be that integrated approach, the fact or the possibility that, for instance, the ICC would not just be the court, but also a potential actor that provides training. Exactly as you said, Serge, you have the capacity to do now.
Brief, please.
Yeah, that was it. Thank you very much.
Thank you. Your question. The gentleman behind you, then you. Okay.
Just briefly, Dave Sheffer, Northwestern University, Ambassador Molokomi. Has any discussion taken place within African councils? There's always a reaction to the ICC, but has there been a proactive set of discussions whereby Africans could come together, African governments could come together to shall we say, more effectively activate the ICC outside of the continent of Africa? All of you have the power as states parties to the statute to refer situations. You can do that as a state party, and yet no one has ever done that with respect to Myanmar or North Korea or the Philippines or Syria. On Syria, and North Korea going to the Security Council and using the influence of the African governments politically with Security Council parties and members to actually have referrals of those matters to the ICC. Bottom line, is there any discussion about activism of that character?
Thank you. Last question.
Chris Marnie from SILREP. Maybe a bit of a follow-on from David, as we've seen this contact group in New York, even from the AU, that there is this capacity engaging on the ICC. But you kind of framed the whole fact that these African states are not pulling out, because of pressure, but you don't consider self-interest. Right? If I'm a leader of a government in an African country and I think, I might be pursued by the ICC, I might also think I'm much better in the Rome Statute where I can set up complementarity. And I have to say I found it a little bit concerning. You're saying, Uganda is cooperating very well. And it's like, yeah, Uganda's cooperating very well if they want to send the ICC at their adversaries and protect them, and the government protecting itself from prosecution. Because that is a calculated approach to engagement with the ICC to preserve impunity for yourself. Staying inside the ICC Rome Statute, you might be better in that situation for self-protection. Then you leave the ICC, and there may be more pressure is on the Security Council to start creating tribunals. And like Mr. Brammertz said, they have primacy of jurisdiction, right? So then all of a sudden you've left the table being the ICC, and all of a sudden you're on the menu, right?
Okay, thank you so much. Brief answers, please. Food is waiting outside. Serge, will you start, please?
Always difficult to give very short answers, but ICC and capacity building. Well, don't know if the solution is to change the mandate, but at least the solution must be to address the problem. Very briefly, if we look at, again, a little bit the lessons learned of the ad hoc tribunals, were in existence for 25 years. The first 10 years cooperation was quite difficult, but the last 10 years, well, capacity building and interaction has been very active. And one model I put in place when I arrived in 2008 was to have liaison prosecutors from Serbia, Croatia, Bosnia working in our office. So they are working now for the last 10 years in our office and have taken last year alone 100,000 pages of documents out of our 9 million pages database to be used in national proceedings. Now, at the ICC, it's of course different because we had one conflict where we worked 25 years. The ICC is having relatively small cases in 25 different situations. So the added value the ICC has for national prosecutions is relatively limited. But the dilemma here is, and I have said it at this conference a few months ago as well, where ICTY has this completion strategy and as a result has really supported national capacity and transferred dozens of cases. The ICC will need a completion strategy in relation to all situations where the ICC is working today, because the ICC opened many situations but never closed any situation. And there are countries where the ICC went in today better, while the majority are even in a worse situation. So my point is much more that if the international community is supporting an investigation by the ICC in a certain part of the world, well, there should be a mechanism put in place to support national capacity building. This is very much what the Academy is doing with WIAMO and with many other partners here present. I really believe that there is a big job to be done in relation to capacity building, but I'm not sure if this should be done by the ICC in situation countries, because I really see a conflict of interest. It will be difficult to work with local prosecutors on their cases to help them, and if they are not successful after the training, you would take the case to the ICC. So I think it should not be the ICC organizing the training and the capacity building. It should really be done by others. Thank you.
Maria? No? Okay. Natalia, please. Yeah. No, she doesn't want to. So, yeah.
I guess I was asked questions. I was just asking the name of the... Are you Christopher? Okay. I like to refer to people by their names. I don't know why Betty is quiet, because I was hoping you would help me on the South Sudan question. Do you feel conflicted?
I'll give Richard the answer at lunch.
Okay. Right. David, interesting. I've attended a few AU summits, and I know that this subject does come up, but my short answer would be that I think, generally speaking, we have been more preoccupied with defending ourselves against the ICC, and to point to other places where the ICC should be instead of focusing in Africa, than in sort of being proactively saying, here are the situations. And I think it may be an interesting process, and some of them might like it, and maybe the legal counsel at the ICC might, but he's so overwhelmed. There's so much to do there and so many things that they have to be concerned about. It's a very interesting perspective to have. Christopher. Yeah, it's possible that some people are feeling some sanctuary. They see, one foot in here might actually, at least there's this framework that protects me. But what worries me sometimes also is the fact that this whole debate and the dynamics and all that, it also makes African leaders want to overstay. It does. And perhaps discourages good leaders from making themselves available. For me, that is what worries me most, and that's why you're not seeing, I don't want to call it a spring, an African spring or something like that. I just worry that there is this maybe unintended, maybe intended consequence that because of this situation, that we are not getting leadership renewal, and people are so fearful of leaving power because of the whole international, criminal justice system. Can I just end maybe by saying that, maybe to go back to your issue, David, I was talking to Mark Kirsten recently, and he was coming up with this interesting observation about Ocampo, who we have, of course, avoided for the past 2 hours. So I'll jump in. He's a journalist, so he wants that. I think that, our African countries, with the Kenyan case, the former prosecutor, Ocampo, was very controversial, and he's not really a friend of Africa because of that. And many people may be celebrating the fact that he seems to be in trouble. Of course, these are all allegations and so on. But when I was talking to Mark, he was saying to me, it's interesting because the independent oversight mechanism at the OTP, which, in Africa we were kind of also a little bit suspicious about. Maybe, David, this is a chance for the AU to say, oh, there we are, you see? Now, this mechanism, why don't we have it go and look? This is an opportunity, some kind of a silver lining to say, yeah, let's see what is in there. Because the ICC, if it's to be credible, the OTP, if it's to be credible, let us have this so-called independent oversight mechanism that we didn't trust as Africans. Look at all that is going on. It may be an opportunity. So I think that the Ocampo affair, at least I said Ocampo. Somebody said Ocampo in this session, and I'll stop there. Thank you.
Thank you. I'll be internally grateful. Barack Obama gave a great speech in Addis Ababa a few years ago, and talking about the limits of power and term limits, and how important term limits are in a democratic society. We Germans are probably not the best to defend this case, as we have a chancellor who's in her 13th year now. But thank you so much for this very lively discussion, and enjoy lunch and have a great day. Bye-bye.